Hi everyone, today we will do legal dictation exercise number 22. You can get the PDF from description box. So ready? Start. Dr. Mukundakam Sarma J. The present writ petition has been filed by the petitioner under Article 32 of the Constitution of India against the impugned administrative order of the High Court of Jammu and Kashmir, respondent number 1, recommending the termination of service of the petitioner who was working as a probationary judicial officer and also against the order issued by the state of Jammu and Kashmir, respondent number 1, on the basis of such recommendation on 3/7/2003, dispensing with the services of the petitioner as a district and sessions judge. The petitioner herein was recommended by the High Court of Jammu and Kashmir for appointment as the district and sessions judge on a temporary basis. This aforesaid recommendation of the High Court was accepted by the government of Jammu and Kashmir and an order of appointment was issued to him appointing him as the district and sessions judge on a temporary basis. It was clearly mentioned in the said order of appointment issued by the state government that the petitioner would remain on probation for a period of 2 years as provided under the Jammu and Kashmir Higher Judicial Service rules. Consequent upon the aforesaid temporary appointment, the petitioner was appointed as 3rd Additional District Session Judge, Srinagar, by order dated 28/8/2000. Thereafter, he was transferred and posted as Additional District and Sessions Judge, Jammu, by issuing an order dated 5/6/2001. At this stage, it is required to be mentioned that in terms of the Jammu and Kashmir Higher Judicial Service Rule, the total period of probation for a judicial officer after his initial appointment could be for 3 years, for when he is initially appointed at the first instance, his probation period is given as 2 years and thereafter the same could be extended by another 1 year. In this connection, reference could be made to Rule 15 of the Jammu and Kashmir Higher Judicial Service Rules, which provides as follows. 15. Probation. All persons shall, on appointment to the services in the substantive vacancies, be placed on probation. The period of probation shall in each case be 2 years, provided that the period for which an officer has been continuously officiating immediately prior to his appointment may be taken into account for the purpose of computing the period of probation. The government may, in consultation with the court at the time, extend the period of probation, provided that the total period of probation shall not ordinarily exceed 3 years. An order sanctioning such extension of probation shall specify whether or not such extension shall count for increment in the time scale. if it appears to the appointing authority at any time during or at the end of the period of probation or extended period of probation or extended period of probation, as the case may be, that a probationer has not made sufficient use of his opportunities or has otherwise failed to give satisfaction, his service may be dispensed with immediately. A person whose services are dispensed with shall not be entitled to any compensation. Thank you. Please subscribe my channel Steno Star.